Hi, my name's Clare Murray and I'm Managing Partner of Specialist Partnership and Employment Law firm CM Murray. Thanks so much for joining us today. We're going to have a chat about the current state of NDAs, and I'm with my partner and our General Counsel, Beth Hale, who is interested in all things NDA related. So Beth, why are we talking about NDAs again?
I think to understand why we're talking about them now, we probably need to look back a few years. That after the Me Too movement kind of broke, there was a lot of focus on not just harassment in the workplace and what was going on and what we could do about that, but also on how that has been covered up over many years, including the use and misuse of non-disclosure agreements, confidentiality provisions, preventing people from speaking up about experiences they've had. And absolutely rightly, a light was shone on how NDAs have been drafted, how they've been used, and how they've been used particularly to cover up kind of where there have been serial perpetrators of harassment in the workplace. And the reason it's come up again now, so I think partly it hasn't gone away, sort of 2017, 2018. Since then, we have been talking about NDAs. Employment lawyers have been thinking hard about how they're drafted and how they're used, and other people have been too. But the reason it's become particularly topical now is because a movement was launched recently, a campaign was launched recently by Zelda Perkins, who was one of the Harvey Weinstein whistleblowers. She broke her NDA to talk about exactly this subject, and a Canadian lawyer called Julie Macfarlane, who and they've together have launched this campaign called Can't Buy My Silence, which is aimed at ending the misuse of NDAs, and they're talking about sort of potentially banning NDAs in harassment cases. So that's why it's come up now, and that's why we're talking about it today.
And I think there was recently also a private members bill.
Yes, Maria Miller, who was chair of the Women Equality Select Committee, she's not anymore, but she still has a strong interest in this area, put forward one of those 10-minute bills in Parliament about the potential banning of NDAs in harassment cases. Nothing further has happened on that, but it's just brought it all back to the public domain and to public attention.
So there are some really strong voices on this issue, sort of quite rightly keeping it alive. And I know you were just on a panel very recently at the Rights of Women conference, which is an amazing organisation. And so what were some of the pros and cons of NDAs that were sort of debated during that session?
Yeah, it was such an interesting conversation. And I think as you rightly say, it's so important to keep the discussion alive and to keep us all thinking about what you use NDAs for and when. So I think the key things that come out of it are the absolutely vital importance of clarity in drafting, and that is something that the Solicitors Regulation Authority have really focused on. They issued a warning notice in 2018 to solicitors who are drafting NDAs to just focus on enforceability. So don't include unenforceable provisions in NDAs just for that sort of deterrent, chilling effect, to focus on enforceability and also clarity, so people understand what they're signing. And I think for me, that is the real key here, is that if you are using an NDA, and I'll come on in a second to whether you should be at all, but if you are putting an NDA into agreement, think about its impact on those signing it, and ensure that everybody understands exactly what they can and can't talk about afterwards. We often include a really, really long list of carve-outs from a non-disclosure agreement, where we say, you can talk to family, you can talk to medical experts, you can talk to therapists, you can talk to the regulator, you can talk to the police. You can blow the whistle in accordance with the whistleblowing legislation. So there's a really long, often longer than the NDA itself, a long list of carve-outs setting out what you can and can't do.
I think the warning notice from the SRA makes it clear as well that should extend into sort of related provisions.
Absolutely. So things like non-derogatory comments clauses, and clawback clauses, and also the warranties that you often see in settlement agreements. It's absolutely clear that you shouldn't be kind of imposing an NDA by the back door. So it's those kinds of carve-outs and the clarity around what people can and can't talk about have to be with all of those, have to apply to all of those provisions as well.
Yeah, and the SRA is starting to take a very active stance on looking at the extent to which that warning notice is or isn't being complied with.
Yeah.
And I do think maybe, historically it wasn't necessarily intentional that employment lawyers were perhaps not as thoughtful on these issues and on these carve-outs. I think, you know, we all fell into at one point or another the sort of the precedent cookie cutter approach, but this is a really useful reminder that whether you are the lawyer advising or the employer or the senior executive, that, you know, the complainant who's the participating in this kind of agreement, that there really needs to be some very careful thought as to what's being included and why. And so if you're the employer, what are the sort of things, just as a headline level, should you be thinking about if you're asking someone, whether it's a settlement agreement, an employment contract, or any other kind of contract which contains confidentiality provisions? What are the key things that they should be thinking about?
I think the first thing to think about is, do you need a confidentiality provision at all? Why is confidentiality important? What are you trying to protect? Who are you trying to protect? What is the purpose of having the confidentiality agreement? I mean, there will be circumstances when it's an absolute no-brainer, where you're trying to protect trade secrets, or you're trying to protect confidential financial information relating to your business, and that, you know, that will be, you know, it's almost always appropriate to have a confidentiality provision in those circumstances. But I think just including an NDA in all settlement agreements, for example, as an absolute standard provision and just a knee-jerk is no longer, it's no longer appropriate. You really need to apply your mind to whether you need an NDA at all, and if so, which information are you protecting?
I think also it's worth mentioning that if you are involved in a matter which is cross-border, we've seen multiple jurisdictions taking different approaches to NDAs, the extent to which they can be included, whether they can only be relied on by the claimant, whether there's any tax relief that's lost in relation to a sexual harassment type complaint if you include an NDA. So it's really important in a multi-jurisdictional agreement to make sure you get local advice from overseas lawyers that can address those issues.
Absolutely.
And what about from a kind of a senior executive or an individual or partner's perspective who's being asked to sign up to this type of agreement? What thoughts would you have for them?
You would really want to make sure that you know what you're signing up to, and I come back to sort of clarity of drafting. And speak to your advisors about exactly what you're signing up to, exactly what it means. And you would want to think about things like, can you talk to future employers, not necessarily about the full circumstances, but about your reason for leaving a previous employer? Are the carve-outs wide enough to allow you to do that? Are there other specific carve-outs for your specific circumstances that you might want to have included? So don't just accept at face value a sort of template NDA. Think about what your specific circumstances are and what you want to see included.
And that could, I guess, include, you might be agreeing to something in respect of your circumstances within limited parameters, but, for example, if you were being asked to be a witness in someone else's related proceedings, what do you think, what are your thoughts on that?
I think you need to be really careful that you understand what you're signing up to. And I think one of and who you're being asked to protect, and also make sure that you're not at any stage being asked to lie, because I think that's one of the things that you get agreements to, historically see agreements to give a reference or to say that you don't know of anything, or and I think just make sure that what you're not being asked to do anything with which you feel uncomfortable.
Okay, look, thank you so much. I think that's really interesting, and I know we could talk for much longer on this topic. It's a really interesting area for us. Thanks so much for listening. If you've got any issues or would like to discuss any aspect relating to confidentiality provisions or NDAs, please do get in touch. We love talking about these issues and thinking about them and some of the more complex and knotty problems around them. Also, please check out our website where we talk about related issues. You can also access some of our other podcasts. There's a fabulous podcast, The Law Down, which some of our colleagues take the lead on, including our colleagues Wanu Sanda and Pooja Dasgupta. And I think there's a new edition about to
land.
about to land, so please check that out. It's a very wry and informal look at some of the employment and partnership law issues behind sort of the top stories in the news. So thanks again for watching and listening. As they say, if you've enjoyed this, then do like and subscribe, and do get in touch as well. Thanks so much, and thanks again, Beth. Take care.
Thanks a lot.